What happens if two people are living together, they're in a committed relationship in New Hampshire, and they break up, or perhaps one of them has to go to a nursing home? Is there such thing as common law spouse? The answer is no, for the most part. New Hampshire has a very limited common law spouse statute. It was created in the 1800s. It is a process upon which, if for 3 years they have been cohabitating, the two people have been cohabitating, and it could be same-sex marriages. We recognize same-sex marriages, so it could be same-sex, male-female. It won't matter for the statute. But they've been cohabitating, they've been acknowledging each other as husband and wife. They've been reputed in the society as husband and wife, and one of them dies. So in this situation, when there's a breakup, common law spouse doesn't exist. So in this limited situation, there could be a circumstance upon which, if you can prove common law spouse, even if the person that died did not take care of, in any type of estate plan, a process for taking care of their significant other, that person may be able to elect what's called a spousal share under the estate, but they're not going to be able to, when a breakup happens, get half of his house. Whereas in a marriage, generally you are able to go forward, and regardless of whose name the properties are in, you can still go forward and make a claim for a marital estate and a distribution by the courts for the marital estate. You can't do that when you're not married. Marriage matters, so getting that license does matter. The common law spouse statute, dealing with acknowledgement, reputation, and 3 years cohabitation, let's deal with that. The acknowledgement means that they actually are acknowledging each other as husband and wife. That's rare in this society now. Back in the 1800s, people were often acknowledging each other as husband and wife even if they didn't have a license. But now they're pretty clear out there of saying, we're living together, we're committed relationship, but we're not husband and wife. They may, if they refer to themselves as a common law spouse, that might help. But also acknowledgement means they're treating each other as husband and wife. I actually had a case where there were 23 witnesses we were defending against a common law spouse, and specifically the reputation in the community was that they were husband and wife. But the allegations by the person that survived was he beat her and he cheated on her. The marriage vows matter for acknowledgement. Saying in the courts, well, married people cheat, married people hit each other, not good. It's not going to work with the courts. So at least in my situation, that didn't work. We were able to show they weren't acknowledging each other as husband and wife, so therefore there wasn't common law spouse. The reputation issue, people are much more upfront about living together, not being married. Even with children together, it's not the 1800s when this statute was created, so it is tough to be able to establish that reputation issue as well. So marriage matters. The common law spouse statute is very limited. I have seen it where it does have some teeth to it, but it's very difficult to deal with, and again, one of you have to die for it to be there. So marriage licenses matter. If you want to be on the property with your significant other, the real estate, make sure your name is on the deed.